Hello and welcome to Mahatma Gandhi Letters. Let's continue to the article, The Grievances of British Indians in South Africa, an appeal to the Indian public. The Indians have, up to now, enjoyed the franchise rights under the General Franchise Law of the colony, which requires ownership of immovable property worth £50 or payment of an annual rental of £10 to qualify an adult male to be placed on the voters' roll. There is a special franchise law for the natives. Under the former, in 1894, there were 9,309 European voters and 251 Indians, of whom only 203 were living at the time, the populations being equal. Thus, the European vote in 1894 was 38 times as strong as the Indian vote. Yet the government thought or pretended to think that there was a real danger of the Asiatic vote swamping the Europeans. They therefore introduced into the Legislative Assembly of Natal a bill disfranchising all Asiatics save those who were then rightly contained in any voters' list. The preamble of the bill stating that the Asiatics were not acquainted with elective representative institutions. Against this bill, we memorialized both the Legislative Assembly and the Legislative Council of Natal, but to no purpose. We then memorialized Lord Ripon and forwarded copies of the memorial to the press and the public in India and England, with a view to enlist their sympathy and to secure their active support, which, we are thankful to say, we received to some extent. As a result, that act has now been repealed and replaced by an act which says, no persons shall be qualified to have their names inserted in any list of electors who, not being of European origin, are natives or descendants in the male line of natives of countries which have not hitherto possessed elective representative institutions founded on the parliamentary franchise, unless they shall first obtain an order from the Governor and Council, exempting them from the operation of the Act. It also exempts from its operation those persons that are rightly contained in any voters' list. This bill was first submitted to Mr. Chamberlain, who has practically approved of it. We yet thought it advisable to oppose it, and with a view to secure its disallowance, have sent a memorial one to Mr. Chamberlain and hope to secure the same measure of support that has been extended to us hitherto. We believe that the real reason for all such legislation is to accord a different treatment to the Indian in South Africa, such that, under it, a respectable Indian in that country may become an impossibility. There is no real danger of the Asiatic vote swamping the European or the Asiatic ruling South Africa. Yet this was the main point urged in support of the bill. The whole question has been well thrashed out in the colony, and Mr. Chamberlain has got all the materials before him to judge. Here are the government giving their own view in their organ, the Natal Mercury, of the 5th March 1896, dealing with the present bill and supporting it. After quoting the figures from the voters' list, it says, "The fact of the matter is that apart from numbers altogether, the superior race will always hold the reins of government. We are inclined to the belief, therefore, that the danger of the Indian vote swamping the European is a chimerical one. We do not consider that the danger of being swamped is at all a likely one, as past experience has proved that the class of Indians coming here, as a rule, do not concern themselves about the franchise, and further, that the majority of them do not even possess the small property qualification required." This admission has been reluctantly made. The Mercury supposes, and we believe, that the bill will fail in its purpose if it is to debar the Asiatic from the franchise, and says that it would not matter if it does. What, then, is the object if it be not to harass the Indian community? The real reason why the bill has been introduced is thus guardedly but frankly stated by the Mercury of the 23rd April, 1896. Rightly or wrongly, justly or unjustly, a strong feeling exists among the Europeans in South Africa, and especially in the two republics, against Indians or any other Asiatics being allowed unrestricted right to the franchise. The Indian argument, or course, is that there is only one Indian to every 38 European voters on the roll at present, with the open franchise, and that the danger anticipated is imaginary. Perhaps it is, but we have to deal with it as if it were a real danger, not altogether, as we have explained, because of our views, but because of the views we know to be strongly held by the rest of the Europeans in the country. We do not want isolation again under the far greater and more fatal ban of being a semi-Asiatic country out of touch and out of harmony with the other European governments of the country. This, then, is the naked truth. In obedience to the popular outcry, justly or unjustly, the Asiatic must be put down. This bill has been passed after a secret meeting was held by the government at which they explained the real reasons for passing the bill. It has been condemned by the colonists and the other newspapers as inadequate from their point of view, and by the very members who voted for it. They hold that the bill will not apply to the Indians because they possess in India elective representative institutions founded on the parliamentary franchise, and that it will involve the colony in endless litigation and agitation. We too have taken up the same ground. We have urged that the legislative councils in India are elective representative institutions founded on the parliamentary franchise. Of course, in the popular sense of the term, we have no such institutions, but in the opinion of the London Times and an able jurist in Durban, our institutions can well be legally classified under those described in the bill. The Times says, the argument that he, the Indian, has no franchise whatever in India is inconsistent with facts. Mr. Lawton, an eminent lawyer in Natal, writing to a newspaper on the subject, says, is there then a parliamentary or legislative franchise in India, and what is it? There is, and it was created by the Acts 24 and 25 Victoria, Chapter 67, and 55 and 56 Victoria, Chapter 140, by the regulations made under Section 4 of the latter Act. It may not be founded on what we call a liberal basis, it may indeed be founded on a very crude basis, but it is the parliamentary franchise nevertheless. And under the bill, it is on it that elective representative institutions of India have to be founded. This is also the opinion of other eminent men in Natal. Mr. Chamberlain, however, in his dispatch 1 in connection with the matter says, I also recognize the fact that the natives of India do not possess representative institutions in their own country, and that they themselves, in those periods of their history when they were exempt from European influence, have never set up any such system themselves. The opinion, as will be noticed, is opposed to the view expressed by the Times partly quoted above, and has naturally frightened us. We are anxious to know what the best legal opinion here is. We cannot, however, too often urge that it is not political power that we want, but it is the degradation which these franchise bills involve that we resist. If a colony is allowed to treat the Indians on a different footing from the Europeans in one respect, there would be no difficulty in going further. Their goal is not merely disfranchisement. Their goal is total extinction of the Indian. He may be allowed to exist there as a pariah, as an indentured laborer, at the most a free laborer, but he must not aspire higher. At the time the first franchise bill was introduced, in response to the clamor for municipal disfranchisement of the Indians, the Attorney General said that would be dealt with in the near future. The Natal government, about a year ago, wished to convene what was called a coolie conference, so that there might be uniformity in Indian legislation throughout South Africa. At that time also, the deputy mayor of Durban moved a resolution that the Asiatics should be induced to live in separate locations. The government are vexing themselves to find out how they can directly and effectively check the influx of the Indian traders, whom Mr. Chamberlain describes to be peaceable, law-abiding, meritorious body of persons whose undoubted industry and intelligence and indomitable perseverance, he hopes, will suffice to overcome any obstacles which may now face them in pursuit of their avocations. The present bill, therefore, we humbly think, has to be taken in connection with these facts and treated accordingly. The London Times has put the franchise question in this form. The question now before Mr. Chamberlain is not an academic one. It is not a question of argument, but of race feeling. We cannot afford a war of races among our own subjects. It would be as wrong for the government of India to suddenly arrest the development of Natal by shutting off the supply of immigrants, as it would be for Natal to deny the rights of citizenship to British Indian subjects who, by years of thrift and good work in the colony, have raised themselves to the actual status of citizens. The second bill that has been passed by the Natal legislature proposes to keep the indentured Indians always under indenture, or if they do not relish it, to send them back to India at the end of the first indenture of 5 years, or if they would not go back, then to compel them to pay an annual tax of £3. How, in a British colony, such a measure could even be thought of passes our comprehension. Almost all the public men in Natal are agreed that the prosperity of the colony depends upon the Indian labor. In the words of a present member of the Legislative Assembly, at the time the Indian immigration was decided upon, the progress and almost the existence of the colony hung in the balance. But in the words of another eminent Natalian, Indian immigration brought prosperity, prices rose, people were no longer content to grow or sell produce for a song. They could do better. If we look to 1859, we shall find that the assured promise of Indian labor resulted in an immediate rise of revenue which increased fourfold within a few years. Mechanics who could not get a wage and were earning 5 shillings a day and less found their wages more than doubled, and progress gave encouragement to everyone from the burg to the sea. Yet they want to tax these industrious and indispensable people who, in the words of the present Chief Justice of Natal, have turned out to be trustworthy and useful domestic servants, after having taken the very lifeblood out of them. The following opinion was held by the present Attorney General 10 years ago. He is now the framer of this bill, which a radical newspaper in London says is a monstrous wrong, an insult to British subjects, a disgrace to its authors, and a slight upon ourselves. With reference to the time-expired Indians, I do not think that it ought to be compulsory on any man to go to any part of the world, save for a crime for which he is transported. I hear a great deal of this question. I have been asked again and again to take a different view, but I have not been able to do it. A man is brought here, in theory with his own consent, in practice very often without. He gives the best 5 years of his life. He forms new ties, forgets the old ones perhaps, establishes a home here, and he cannot, according to my view of right and wrong, be sent back. Better by far to stop the further introduction of Indians altogether than to take what work you can out of them and order them away. But now that which was meritorious 10 years ago in the Indian, namely his service to the colony for 5 years for a paltry wage, has become a crime for which he would deserve transportation to India if the Natal Attorney General be allowed to do so by the Indian and the home governments. I may mention that the Indian government, on the representation of an ex parte commission one that visited India from Natal in 1893, have accepted the principle of compulsory indenture. We, however, are hoping confidently that the facts brought out in the memorials to the home and the Indian government's one are sufficient to induce the latter to alter their views. Although we have not moved in the matters specially affecting the Indians now serving their indenture, one may well presume that their lot will not be practically comfortable on the estates. We think that the alteration in the colony's tone with regard to the general population will affect the masters also of the indentured Indians. 1 or 2 matters, however, I have been asked to especially bring to the notice of the public. A representation was made, even as far back as 1891, by an Indian committee headed by Mr. Haji Muhammad Haji Dada, one of the prayers whereof being that the protector of immigrants should be a man knowing the Tamil and the Hindustani languages, and should, if possible, be an Indian. We have not receded from that position, but the interval has merely confirmed that opinion. The present protector is an estimable gentleman. His ignorance of the languages, however, cannot but be a serious drawback. We humbly consider also that the protector should be instructed to act as an advocate for the Indian more than as judge between the employers and the immigrants. I shall illustrate what I say. An Indian named Balasundaram was, in 1894, so ill-treated by his master that 2 of his teeth were nearly knocked out. They came out through his upper lip, causing an issue of blood sufficient to soak his long turban in it. His master admitted the fact, but pleaded grave provocation, denied by the man. On receiving the punishment, he seems to have gone to the protector's house, which was close by his master's. The protector sent word that he must go to his office the next day. The man went then to the magistrate, who was much moved at the sight. The turban was kept in court, and he was at once sent to the hospital for treatment. The man, after having been kept in the hospital for a few days, was discharged. He had heard about me and came to my office. He had not recovered sufficiently to be able to speak. I asked him, therefore, to write out his complaint in Tamil, which he knew. He wanted to prosecute the master so that his contract of indenture might be cancelled. I asked him if he would be satisfied if his indenture was transferred. On his nodding consent to what I said, I wrote to his master asking if he would consent to transfer the services of the man. He was at first unwilling, but subsequently consented. I sent the man also to the protector's office with a Tamil clerk of mine who gave the man's version to the protector. The protector desired the man to be left in his office and sent word that he would do his best. The master, in the meanwhile, went to the protector's office and changed his mind, saying his wife would not agree to the transfer because his services were invaluable. The man was then said to have compromised and to have given the protector a written document to the effect that he had no complaint to make. He sent me a note to the effect that as the man had no complaint to make and his master did not consent to transfer the services, he would not interfere in the matter. I asked if this was right. Was it right for the protector to have taken such a document from the man? Did he want to protect himself against the man? To proceed, however, with the painful story, naturally the note sent a shock through my body. I had hardly recovered when the man came to my office crying and saying the protector would not transfer him. I literally ran to the protector's office and inquired what the matter was. He placed the written document before me and asked me how he could help the man. He said the man should not have signed the document, and this document was an affidavit attested by the protector himself. I told the protector that I should advise the man to go to the magistrate and lodge a complaint. He said the document would be produced before the magistrate and it would be useless. He advised me, therefore, to drop the matter. I returned to my office and wrote a letter to his master imploring him to consent to the transfer. The master would do nothing of the kind. The magistrate treated us quite differently. He had seen the man while the blood was yet dripping from his lips. The deposition was duly made. On the day of hearing, I explained the whole circumstances and again appealed to the master in open court and offered to withdraw the complaint if he consented to the transfer. The magistrate then gave the master to understand that, unless he considered my offer more favorably than he seemed to do at the time, consequences might be serious for him. He went on to say that he thought the man was brutally treated. The master said he gave provocation. The magistrate retorted, "You had no business to take the law in your own hands and beat the man as if he were a beast." He adjourned the case for one day in order to enable the master to consider the offer made by me. The master, of course, came down and consented. The protector then wrote to me that he would not agree to transfer unless I submitted a European name he could approve of. Happily, the colony is not quite devoid of benevolent men. A Wesleyan local preacher and solicitor, out of charity, undertook to take over the man's services, and thus ended the last act of this painful drama. Comment is superfluous as to the procedure adopted by the protector. This is only a typical instance, showing how hard it is for the indentured men to get justice. We submit that no matter who he is, his duties should be clearly defined as are those of judges, advocates, solicitors, and others. Certain things for the sake of avoiding temptations he should not be able to do in spite of himself. Just fancy a judge being the guest of a criminal who is being tried before him. Yet, the protector, when he goes to the estates to inquire about the condition of the men and to hear complaints, can and does often become the guest of the employers. We submit that this practice is wrong in principle, no matter how high-minded the protector may be. As a surgeon superintendent of immigrants remarked the other day, the protector should be easily approachable to the meanest coolie, but he should be unapproachable to the lordliest employer. He may not be a Natal man. It also looks a strange procedure to appoint as protector a member of a commission whose object is to induce the Indian government to consent to pass harsher laws for the indentured Indians. When the protector has to perform such a conflicting duty, who is to protect the indentured men? It should be easy for the immigrant to have his services transferred. There are in the Gale some Indians who have been there for years because they refuse to go to their employers. They say they have complaints which, owing to the peculiar circumstances in which they are placed, they cannot substantiate. A magistrate was so much disgusted with the business that he wished he had not to try such cases. The Natal Mercury of 13th June, 1895, thus comments on such a case. When a man, even a coolie immigrant, prefers to go to prison rather than work for the master to whom he has been indentured, the natural inference is that something is wrong somewhere, and we are not surprised at Mr. Dillon's remarks on Saturday when he had 3 coolies before him, all charged with the same offense of refusing to work, all giving the same excuse, viz., that they were ill-treated by their masters. Of course, it is just possible that these particular coolies prefer Gale work to plantation work. On the other hand, it is just possible that the coolies have some ground for their complaint as to their treatment, and the matter is one that ought to be investigated. And at least these men who complain in this way should be transferred to another master, and if they again refuse to work, it can be readily seen that they do not want to work. If a coolie is ill-treated, it may be said that he can complain to the magistrate, but it is not an easy matter for any coolie to prove such cases. It is a matter altogether for the protector of immigrants to inquire into and remedy, if possible. There is an immigration trust board that consists of employers of Indians. They have now received very wide powers, and seeing the position they occupy, their acts will have to be very jealously watched by the Indian government. The punishment for desertion is heavy enough, and yet they are now seriously considering whether some stiffer mode of dealing with such cases could not be devised. It should be remembered, however, that, in at least 9 cases out of 10, the so-called deserters complain of ill treatment, and such deserters are protected under the law from punishment. But as the poor fellows cannot establish their complaints, they are treated as real deserters and sent by the protector to the magistrate for punishment accordingly. Under such circumstances, any alteration for the worse in the law about desertion should, we submit, require careful consideration. There is a sad mortality among these people from suicides. They are not satisfactorily accounted for. I cannot do better than quote the Advertiser of the 15th May 1896, a feature of the annual report of the Protector of Immigrants to which more public attention should be given than is the case, is that referring to the number of suicides which take place every year among the indentured coolies on the estates. This year, the number recorded is 6 out of a total of 8,828. A large number occurred in 1894. It is, however, a very high percentage and raises the suspicion that on some estates a system of treatment exists towards the coolie laborers, much akin to slave driving. It is extremely significant that so many suicides should occur on certain estates. This is a point which calls for investigation. Apparently, no inquiry of any kind is held into the cases with a view to ascertain whether the treatment meted out to unfortunate wretches, who prefer death to life, is such as to render existence an intolerable misery. The matter is one which is apt to pass unnoticed. It, however, ought not to do so. In a recent case of desertion on the part of several coolies from an estate down south, the prisoners openly declared in court that they would rather kill themselves than return to their employer. The magistrate said he had no option but to order them back to serve out their indentures. It is time the colony took steps to afford such complainants an opportunity of bringing the facts in connection with their complaints before some court of inquiry and the public. It is also desirable that a Secretary of Indian Affairs should be added to the ministry. As matters stand at present, the indentured Indian has no effectual mode of appeal against whatever brutality may be inflicted on him on the plantations. We, however, wish to guard ourselves against being understood to say that the life of the indentured Indians in Natal is harder than in any other country, or that this is a part of the general grievances of the Indians in the colony. On the other hand, we know that there are states in Natal where the Indians are very well treated. At the same time, we do humbly submit that the lot of the indentured Indians is not all that it might be, and that there are points which require attention. When an indentured Indian loses his free pass, he is charged £3 for the duplicate. The reason for this is the alleged fraudulent sale by the Indians of their passes. But surely such fraudulent sale can be criminally punished. A man who has sold his pass should never be able to get a duplicate, even on a payment of £30. On the other hand, it should be as easy for an ordinary Indian to get a duplicate as the original. They are supposed to carry their passes about their persons. No wonder if they are frequently lost. I know a man who could not get a duplicate because he had not £3 with him. He wanted to go to Johannesburg and he could not go. The practice in the Protector's Department in such cases is to issue temporary passes so that the men may be able to make a present of their first £3 earned to the Protector's office. In the case I am referring to, the man had a temporary pass issued for 6 months. He could not earn £3 during that time. There are dozens of such cases. I have no hesitation in saying that this is nothing but a system of blackmail. Dear friends, let's continue the speech in next episode. Thank you for listening to Mahatma Gandhi Letters.